We've invited several prominent industry participants to share their organization's views on the state of music licensing and the consent decrees. I will briefly introduce them one at a time, and each will have the opportunity to make a statement. There will be no Q&A for this session. You can find more complete bios of each of the panelists on the workshop's website. We'll start by hearing remarks from Elizabeth Matthews, the Chief Executive Officer of American Society of Composers, Authors, and Publishers, better known as ASCAP, a membership association of more than 750,000 US composers, songwriters, lyricists, and music publishers. ASCAP licenses the public performance of its members' music, collects license fees, tracks performances, and distributes to its members royalties based on their performances. Beth Matthews, I'll now turn it over to you.
Hello, everyone. My name is Beth Matthews, and I'm the CEO of ASCAP, the American Society of Composers, Authors, and Publishers. Before I begin, on behalf of ASCAP, I wanted to thank Makin Delhar-Rahim and his team at the U.S. Department of Justice for providing us with the opportunity to discuss the modification of the ASCAP and BMI consent decrees. ASCAP is an unincorporated membership association formed by songwriters back in 1914, over 106 years ago. We operate on a not-for-profit basis, and we have over 750,000 songwriter, composer, lyricist, and music publisher ASCAP members. Every time you hear a song, two separate copyrights are implicated, the musical composition and the sound recording. ASCAP and BMI only license the public performance rights in the musical composition. If you hear a song performed publicly, then it is more likely than not that the music user has a blanket license from both ASCAP and BMI. Together with BMI, we account for over 90% of the US market in public performance rights. We aggregate shares of musical compositions and license them directly in the US on all platforms: AM/FM, satellite radio, broadcast and cable television, streaming music and audiovisual services such as Spotify, Amazon, Netflix, also retail establishments, bars, grills, and restaurants. At ASCAP, we license the music, we collect the money, and then we take the digital performance files and cue sheets, and we identify, process, and match over 1 trillion musical performances each year in order to pay the correct ASCAP member their royalties by using our proprietary matching algorithm. Both ASCAP and BMI license our music over a network of 100 not-for-profit collective management societies all over the world. All of these CMOs are connected to one another via digital tools and tech platforms to help us manage and track our data and musical performances so that we may legally license US musical repertoire on a global basis and pay the right ASCAP member their share of royalties from other countries. Because foreign collection management societies do not operate under consent decrees, they are typically allowed to aggregate intellectual property rights other than the right of public performance, such as mechanical and synchronization rights, in order to drive market efficiencies for both buyers and sellers. Every dollar that ASCAP collects in licensing revenue, nearly 90 cents is returned to our ASCAP creator and music publisher members in the form of royalties. The remaining 10+ cents covers our overhead. As the United States Supreme Court noted in the CBS case, the model of collective licensing, or aggregated clearance of copyrights, is an extremely efficient market tool because it is a business of scale at low transactional costs for both buyers and sellers. For creators and music publishers, collective licensing is essential. They don't have to worry about licensing hundreds of thousands of US businesses, collections, or matching and processing performances, and instead they may focus their efforts on the creative process and keep creating the music that we all love. For licensees, collective licensing is also essential. It is simply not practical for a licensee to transact separately with 2 million ASCAP members and BMI affiliates in order to avoid claims of copyright infringement and figure out how to get all of the stakeholders paid. By entering into blanket license agreements with ASCAP and BMI, they have immediate access to 90% of the world's greatest music. It is common for most people to assume that the person who sings a song actually wrote the song, but that is often, as Leanne described, not the case. Songwriters and composers are typically not famous, and you would probably never recognize their name unless they were also a recording artist. They are the unsung heroes behind American music. Without songwriters, recording artists would have nothing to sing, and streaming services would have nothing to stream. Without composers, your favorite TV shows and movies would not be as compelling because their music actually drives the story. Songwriters and composers are dependent upon ASCAP and BMI because they often do not have salaries, healthcare benefits, or other reliable sources of income. Composers in particular are at risk because they are subject to work for hire agreements, and they are often pressured to accept buyouts or lose an opportunity to find work. Usually, royalties from ASCAP and BMI are a music creator's only source of income. The problem is that it's becoming harder and harder for songwriters and composers to make a living, and without songwriters, there simply is no music. One of the primary reasons that the marketplace is no longer working for songwriters and composers is that both ASCAP and BMI operate under consent decrees that were entered into in 1941 when the marketplace was entirely different. Consent decrees are supposed to sunset after 10 years pursuant to DOJ policy in place since the 1970s. Our consent decrees, however, have been in place for almost 8 decades. And back in 1941, there was very little competition in the public performance space. Terrestrial radio was the only form of mass media. The antitrust laws were quite different, and there was a genuine concern that ASCAP and BMI had too much leverage over licensees. Fast forward 80 years and the world looks very different. Today, competition is alive and well in the music marketplace. There are more PROs and more licensees than ever before, and it's not all about terrestrial radio. Today, there's broadcast, cable, MVPDs, and a thriving OTT industry. Barriers to entry for new market competitors are quite low, and new competitors are rapidly entering the PRO and distributor space. The competition law has evolved and changed, and direct licensing by music publishers has dramatically increased. Licensees are large, complex, powerful, mega technology and media companies, especially the FANG companies, Facebook, Amazon, Apple, Netflix, and Google. They are smart, savvy, all lawyered up, and wildly under-regulated. I have yet to sit in a negotiation with one of these licensees and not feel as though songwriters' hands were tied behind their backs due to the consent decrees. It is crazy to think that in 2020, songwriters are more regulated than Facebook. The other factor that has changed is that consumers no longer buy music, they stream it. They no longer watch linear feeds. They binge on entire seasons of arguably some of the most compelling content in history on an on-demand basis. The good news is that more music is being consumed today than ever before because of the present on-demand consumption habits of consumers. However, the bad news is that while there has been tremendous growth in musical performances, the growth of payments for music publishers, songwriters, and composers has simply not followed suit. Today, songwriters are being diluted from dollars to fractions of pennies on streaming services, and composers are increasingly not given an opportunity to share in back-end royalties when a show is successful. ASCAP and BMI need to be able to compete freely and against unregulated market actors in order to escalate innovation. If we can compete and innovate, then we can meet future market needs. What is clear to ASCAP and BMI is that licensees are not our enemies. They are our partners and they are our customers. We believe that competition is good, that competition drives innovation and efficiencies, that competition creates healthy economies. Today, ASCAP and BMI are not allowed to compete on a level playing field, even with their unregulated counterparts like CSAC and GMR, which has created market-wide imbalances and, frankly, confusion. The consent decrees are wildly outdated and need to be harmonized and simplified. At a minimum, a bare minimum, ASCAP and BMI decrees should be modified to be the same. Today, ASCAP and BMI are not even on a level playing field with one another, which further distorts the marketplace. To prepare for a new world order of global distribution, live data exchanges, demand and supply side pricing, and experimental licensing initiatives, we have to be able to compete and innovate in a global market. All we ask of the licensee community and the DOJ is that you help us modernize our outdated decrees. We do not seek an immediate termination of our consent decrees because we think everyone in this marketplace needs time to adjust and to prepare. Instead of ripping off an 80-year-old Band-Aid, we suggest new and improved decrees that put all stakeholders on a pathway to an eventual free market. My good friend Mike O'Neill, the CEO of BMI, will cover some of the details of our proposal. Our measured approach is designed to minimize disruption in the marketplace for songwriters and publishers, but also to address the concerns of licensees. You should know that we compete fiercely like Pepsi and Coke. So you may think it's a little strange for two competitors to have come together in full alignment on consent decree reform, but we both know that this is a problem that requires industry-wide cooperation. We both feel strongly that we must create reliable and transparent data for licensees in order to drive a sustainable ecosystem for creators and for music publishers. We believe that all licensees have the right to know what fractional share interest they are licensing from us. To that end, ASCAP and BMI are continuing to work on an initiative called SongView to provide a repertoires. Our goal is to launch by the end of 2020. All we ask of the DOJ and the licensing community is please do not leave songwriters and composers and lyricists back in 1941. Thank you.
Thank you, Beth. Next, we will turn to David Israelite, who will be followed by Michelle Lewis, Executive Director of Songwriters of North America. But first, David Israelite is President and CEO of the National Music Publishers Association, the trade association representing American music publishers and their songwriter partners. The NMPA's mission is to protect and advance the interest of music publishers and their songwriter partners in matters relating to the domestic and global protection of music copyrights. David, the mic is yours.
Thank you. And thank you, Assistant Attorney General Del Rahim and the entire Antitrust Division for this opportunity to speak on really what is the most important issue facing songwriters today. My name is David Israelite. I serve as the President and CEO of NMPA, which is the principal trade association representing all U.S. music publishers and their songwriting partners. We are the voice of both small and large music publishers and their songwriters. We are governed by a board comprised of both major and independent music publishing companies, as well as songwriters themselves. Prior to leading NMPA, I worked at the Department of Justice as Deputy Chief of Staff and Counselor to the Attorney General. During my tenure, I had the privilege of serving as chairman of the department's Intellectual Property Task Force, which examined all aspects of the DOJ's handling of IP issues. An important part of our task was to promote free market principles and to protect creators' rights in the digital age. I'm honored to continue that work by representing the music publishers and songwriters who still fight to have their songs valued in a free and fair market. The 2018 Music Modernization Act represented a major step forward for songwriters and publishers and greatly improved the landscape for licensing digital mechanical rights. Despite that progress, music publishers and songwriters continue to be constrained in their ability to realize fair market value for the public performance of their works because of the World War II era consent decrees governing ASCAP and BMI. This has become particularly problematic as digital streaming has emerged as the primary method of music consumption. Major global technology companies that operate music streaming services, such as Amazon, Google, and Apple, hide behind the consent decrees, which were not designed to protect them, to avoid negotiating in a free market what they pay for music. The consent decrees were never intended to protect digital giants, who they themselves made monopolies from songwriters and small business owners. In fact, the consent decree specifically contemplated the exact opposite power balance, one in which small licensees would be protected from large collectives. To remedy this historical misapplication of antitrust law, the ASCAP and BMI consent decree should be modified to permit copyright owners to withdraw their digital performance rights from the ASCAP and BMI repertoires if they so choose. This practice, known as selective withdrawal, would enable publishers and songwriters to decide whether to continue to license their digital rights through their PRO or to negotiate directly with the music streaming service. To be clear, selective withdrawal would preserve the current blanket licensing system for the vast majority of licensees, including bars, restaurants, hotels, terrestrial broadcasters, and film and TV companies. Selective withdrawal would only impact digital streaming services, who already engage in direct licensing negotiations with the very same music publishers and songwriters for other types of rights. The current system is one in which music publishers and songwriters face an unfair choice when it comes to licensing their digital performance rights. They can withdraw their works entirely from ASCAP and BMI and lose the benefits and efficiencies of blanket licensing altogether. Or they can leave their catalogs entirely with their PROs, losing the benefit of negotiating performance rights directly with streaming services and suffer under the burdensome regulation of the decrees. There is no reason these options should be mutually exclusive. The prohibition on selective withdrawal is not rooted in copyright law or in antitrust law, and a change is long overdue. In fact, such a change is actually complementary to the existing consent decrees. If ASCAP and BMI are being regulated because they are deemed too big, the Department of Justice should support the right of property owners to exit, thus leaving the regulated companies less powerful. The context of the Copyright Act is informative. Under U.S. law, the owner of a musical work has several exclusive rights, including the right to perform the work publicly. Anytime a song is streamed online or played on the radio, on television, or in a business establishment, the user must first obtain a license from the copyright owner. Congress deliberately left this right in the free market, similar to the rights regarding video synchronization and lyric licensing. Selective withdrawal would allow songwriters and music publishers who are not the subjects of antitrust enforcement to exercise their constitutional and statutory rights. Selective withdrawal is consistent with the purpose of the consent decrees. The decrees were intended to protect traditional businesses that use music from anti-competitive threats posed by the comparatively larger market power of the licensing collectives, while preserving the benefit of blanket licensing. However, the decrees did not and could not have accounted for the vastly different power dynamics that exist in the market today with regard to digital services. Today's digital licensees are valued in the trillions of dollars. The vast majority of music streamed in the U.S. is consumed by one of 5 very large digital service providers, or DSPs: Amazon, Google, Apple, Spotify, and XM Sirius, which owns Pandora. These companies, both individually and collectively, dwarf not only every individual music publisher, but the entire music publishing and songwriting industry as a whole. Tomorrow, the House of Representatives Judiciary Committee will hold a hearing with the CEOs of Amazon, Google, Apple, and Facebook to address antitrust concerns related to their dominance in the digital market. What do all of those giant technology companies have in common? They are all being unfairly advantaged in their negotiations with songwriters due to antiquated consent decrees from 1941. Pause for a moment and think about that. Due to the unintended consequences of consent decrees that never end, the giant technology companies that will be under congressional scrutiny tomorrow are being protected from songwriters. These companies are nothing like the fledgling broadcast industry of the 1940s, yet they benefit from the same protections. The application of the consent decree simply does not make sense when it comes to DSPs, who are able to license performance rights directly and whose market power is exponentially larger than that of the music publishers and songwriters. These tech giants do not need market regulation to shield them from the bargaining power of songwriters. They can and should be negotiating these rights in a free market. They are fully capable of licensing music directly. They do it all the time. All of the digital streaming companies in the market negotiate directly with record labels for the use of sound recordings without a consent decree or statutory license hanging overhead. They also negotiate with other PROs that operate in the free market that are not subject to consent decrees. They even negotiate directly with publishers and songwriters for lyric and video synchronization rights in a free market without a PRO-like middleman. The entire economic chain of a digital services business exists in the free market with the singular exception of paying for musical compositions. Digital services are absolutely capable of obtaining licenses in a free market. They would just prefer not to do so. But convenience alone is not enough to curtail the rights of creators without a basis in copyright law or antitrust law. The prohibition on selective withdrawal is not rooted in antitrust law. It only exists as a matter of consent decree interpretation. Furthermore, the prohibition on selective withdrawal does not serve any actual antitrust purpose. It does not stop or prevent ASCAP or BMI from engaging in any competitive practices. The opposite. It stops publishers and songwriters from engaging in pro-competitive practices. This impact is especially improper considering that antitrust law is an enforcement mechanism, not a regulatory one. The prohibition reaches beyond the realm of antitrust enforcement to act as a de facto regulation on music publishers and songwriters who were never alleged to have violated antitrust law in the first place. To be clear, NMPA supports the other ASCAP and BMI proposed modifications to the consent decrees with selective withdrawal of digital rights as part of such new decrees. There is a reason that in 1979, the Department of Justice determined that all future consent decrees would sunset within 10 years. It is simply impossible to predict changing market circumstances that far into the future. While the department may find justification for continuing the decrees in certain situations, there is no justification for continuing them when it comes to the digital streaming world. Selective withdrawal will preserve the traditional blanket licensing system for the traditional licensees for whom it was designed, while creating a fairer and more competitive digital marketplace for performance rights. Thank you.
Thank you, David. Michelle Lewis will present next, followed by the Honorable Gordon Smith, President and CEO of National Association of Broadcasters. But first, Michelle Lewis, who is a singer, songwriter, composer, and music creators' rights advocate, and currently serves as the Executive Director of Songwriters of North America, SONA, a nonprofit she co-founded in 2014 in response to the complexities and disparities in digital royalties paid to songwriters and composers. So whenever you're ready, Michelle.
I'm Michelle Lewis, here in Valley Village, California. I'm the Executive Director of Songwriters of North America, aka SONA, and I'm also an American songwriter, and I'm on the board of ASCAP. First of all, I want to thank Maken Rahim and the Antitrust Division of the U.S. Department of Justice for inviting me to give an opening statement today. If there's anything I hope you take away from my presence here today, it's that the people who create music should be considered and included in any deliberation about consent decrees that govern ASCAP and BMI, as we are very much affected by them. Having me here is an appreciated gesture towards that end. SONA is a creators' rights organization. Sorry, I'll unbalance there. Like National Songwriters Association International, the Music Artists Coalition, and the Society of Composers and Lyricists, we are a membership organization, which means we spend our time and resources building and educating our communities and teaching songwriters how to advocate for themselves. We are entirely volunteer run, myself included, and our membership is varied and diverse. We have members whose names you would recognize, who've had #1 hits, spent years on the charts. And we have members who are just starting out, working full-time jobs as they learn how the business works. But the majority of our members are like me, middle-class songwriters, who working behind the scenes, whose names you don't know, but whose work you do. In fact, the work of SONA's members is all over the radio, all over TV, all over the streaming platforms, in video games and in movies. And in the before times, they were in bars and restaurants, stores, and gyms. And hopefully we'll get that back. In fact, so I'm here to remind you that our music and the music of songwriters and composers around the country is the reason you're all here. It starts with us. Without the songs, there wouldn't be much to talk about in these workshops, would there? So as you discuss these consent decrees over the next 2 days, I ask that you think about protecting not just the people who license music, but the people who create that music. Even when there isn't a songwriter or composer on a specific panel, like in session 2, where the conversation may be a bit limited without a composer participant. As a songwriter, our songs are all we have. If you don't perform your songs, you don't have tickets or t-shirts to sell. And a songwriter just has her songs. Those songs are everything. Even though I've made a living almost entirely from writing songs for the past 20 years, I have to admit, I didn't know about consent decrees until 5 years ago. In 2015, when I saw that a hit song that I had written, a song called Wings for the group Little Mix, had earned fractions of a penny per stream, adding up to virtually nothing despite millions of streams on digital services and millions of views on YouTube, and I got to experience the new reality for songwriters in real time. All the songwriters I knew were experiencing the same thing. Even when we managed to score a hit, it didn't generate significant income from streaming. Several of us ended up in the office of the attorney, Dina Lubell, who proceeded to school us on all the regulations that bind a songwriter's income. the Copyright Royalty Board on the mechanical side, and consent decrees on the performance side. Imagine being a professional songwriter for 15 years and learning for the first time that the U.S. Department of Justice's Antitrust Division has a role in determining how and what you get paid. It's pretty shocking. While it may seem normal to the attorneys here, for those of us holed away in our studios, churning out our life's work day after day, it makes very little sense how an antitrust decision made in 1941 would have any bearing on what we get paid now. So it's incredibly significant for me to be here today because when I think about Sona's origin story, I realized that my songwriter friends and I founded Sona because of the consent decrees during the last period of Justice Department review. Having learned what the consent decrees were, we were inspired to remind the attorneys of the division back then there are human songwriters and composers that have to live with the effects of their decisions. We participated in the review process then in good faith. We made phone calls, we met with attorneys in the division, we wrote letters, and at the time we were asking for regulatory relief in a rapidly changing music ecosystem that everyone has been describing so far. A lot of the things we were asking for were in the Songwriters Equity Act at the time. But after a year of all those phone calls and meetings, after asking the division for help and relief, the answer we got back on all of our issues was no, and compounded by a ruling on 100% licensing that would have made getting paid for our work even more difficult. This is where it gets a little weird for me, admittedly, because at that point in 2016, my brand new organization, our little 501c that could, sued the Antitrust Division of the Department of Justice over that ruling. Sorry. BMI also challenged the ruling and asked its rate court to declare that its consent decree doesn't require full works licensing. Their rate court judge agreed and eventually got the ruling overturned. But while we're here, let me just reiterate how bad 100% licensing would be for songwriters, since it keeps coming up as a potential change. Aside from it being an illegal taking of our property because our work could be licensed by parties we haven't authorized, it would throw our personal businesses into chaos. Individual songwriters would have no way to track or ensure payment if their royalties were collected by a PRO that they have no relationship with. There would be endless disputes and lawsuits, and it wouldn't work as well for the licensees as they think it would, since many songs legally can't be licensed on a 100% basis anyway. All of this remains true. In any case, after BMI won their case, we were happy to withdraw our suit without prejudice. So we're good now, hopefully. All right, we can move on. After that, Sona moved on to advocating for the Music Modernization Act, which thankfully passed and included some really good provisions for our performance royalties, including being able to use comparable rates for the master as evidence in rate court, and a new rule requiring that judges overseeing the consent decree proceedings will be chosen randomly from a wheel of judges, which as a non-lawyer, I think is a really funny visual. But even with those changes, we're still being threatened. There are looming threats from licensees about going to the Hill with new legislation that would basically create a compulsory license for our performance royalties, which would be awful for us. We would like less regulation, not more, and it's the opposite direction from a free market. So now songwriters find ourselves in a squished position between the rock of rate court and a hard place of compulsory licensing. It really isn't fair. So over 5 years, our rallying cry has gone from, please help the songwriters, to, please don't hurt us. And that's not fun either. So we understand that ASCAP and BMI have come up with a proposal for revised decrees. And if those decrees create a more level playing field for songwriters, then it seems like a fair and reasonable middle ground. I also want to be very clear that despite the decrees, Sona supports a healthy PRO system. For nearly all of us, signing up with ASCAP or BMI was our first step in making money as a music creator. And middle-class songwriters and composers rely on them so much. When Sona does educational events, we ask the songwriters in the audience what their PRO does for them. The answers are always the same. They mention the networking events, the collaborator connections, hand-holding through the works registration process, and the member services. And of course, they mention getting paid. But because we're songwriters, the personal connections are important to us. PROs are our PROs are our home bases, our touchstones. The writer shares of our songs, which we entrust to the PROs, to our chosen PROs, are sacrosanct. It's what we understand and what we connect to. Therefore, we do support the ASCAP and BMI ask for a streamlined decree with its 4 tenets as a pathway forward. If you do revise the consent decrees, however, on behalf of SONA's songwriters and composers, I ask first that you do no harm. This means please don't put 100% licensing back on the table or do anything to undermine the rights of songwriters to be paid for their writer share through the PRO of their choice. Also, please tread carefully with the publisher's ask for selective withdrawal, or most of all, don't make any other changes that might result in compulsory legislation. Whatever you do, please remember the creators. Keep us in the conversation. Include songwriters, include composers. We are the ones who will be the most impacted by whatever decisions you make. No one is more affected by the changes to the decrees than us. So we need you to help us. We're the quintessential little guy. We don't have the resources or lobbyists that the other stakeholders do, but we do have heart. We do have music. And without songwriters, there is no music. Without the music, there's no music business. And so if you want to protect the music business, I implore you to protect the songwriter. Thank you for your time.
Thank you, Michelle. Now we will hear remarks from the Honorable Gordon Smith, who will be followed by Michael O'Neill, President and CEO of BMI. First, Senator Smith joined the National Association of Broadcasters as President and CEO in 2009. Prior to joining NAB, he served as a 2-term U.S. Senator from Oregon and later as a senior advisor in the Washington offices of Covington and Burling. The floor is yours, Senator.
Let me start by wishing you all a good afternoon and express thanks and appreciation to my esteemed friend, the Assistant Attorney General of the United States, and also appreciation to the Department of Justice for inviting me to offer my thoughts as the President and CEO of the National Association of Broadcasters on the future of the ASCAP and BMI consent decrees. On behalf of America's local radio and television broadcasters serving communities across the country, I and we welcome this opportunity to discuss why the ASCAP and BMI antitrust consent decrees continue to have a place, if not to be essential, and our very significant concerns with the so-called modified skinny decrees currently under consideration. Without the framework the current consent decrees provide, whether perfect or not, it is easy to see that a fair competitive market for the licensing of musical works then and today simply would not exist. Despite the Department of Justice finding less than 5 years ago that the decrees were essential to preserving competition, we're yet again being asked to consider modifications to them. For broadcasters and many other licensees, this endeavor raises some very major concerns. While NAB always welcomes conversation about ways to improve and modernize government regulation, most of the publicly proposed modifications would likely harm licensees and consumers. It would stifle innovation and, frankly, entirely miss the point. At the outset, it's critical to recognize that these decrees have been worked through line by line over the course of 80 years, with the parties and the courts developing understandings and interpretations of nearly every word. While getting skinny sounds like an appealing aspiration, especially at my age, in this instance, it's actually quite misleading. Changing or eliminating sections or paragraphs or sentences or even words in the decrees can have harmful and unintended consequences. These are not changes that can be consummated following a workshop or a roundtable. If the decrees were to be modified, That could and should only come after the public fully vets any specific proposals to do so. Moreover, there are three critical issues that we hope and really insist the DOJ must address before we get to any of the subjects on the agenda for these roundtables. The first of these is fractional licensing. It's been mentioned already. The single biggest change to the PRO consent decree landscape in the last few decades is a federal court's recent mistaken interpretation that the decrees do not require full work licensing. As a result of this ruling, licensees may very well pay ASCAP or BMI for the right to publicly perform works, but actually have no right to use them. Any discussion of modifying the decrees must start with requiring whole work licensing through indemnification or some other mechanism that may be created. Second, also somewhat buried in the details of the roundtable is the PRO's failure to be transparent about their repertories. Shockingly, there is no real-time database among the PROs that indicates with any certainty for what compositions licensees have contracted. We don't know. What other business is asked to pay for something and yet have no way of knowing what is included in what you're buying? This issue is exasperated by the federal court's refusal to find that the existing decrees require whole work licensing. Finally, the Justice Department should reassess the breadth of the parties to which these consent decrees apply. With the growth of CSAC and the emergence of powerhouse PRO, global music rights, broadcasters and other licensees are left without full protection under DOJ's watchful eye. If we're going to get serious about reforming the decrees, all PROs must be brought within that purview. PROs do not compete with each other for licensees, and licensees are effectively forced to license each PRO's repertory. This too has been made worse by fractional licensing, as even a relatively smaller PRO could simply amass minority interests in key works and force licensees to pay above market prices for the right to make use of their ASCAP and BMI licenses. So when it comes to the modification that are publicly proposed by ASCAP, BMI, and the National Music Publishers Association, we plead with the Justice Department to proceed with extreme caution. For radio broadcasters, being able to play a wide array of music is essential, and that is what listeners expect and demand. Whether one owns one radio station or hundreds, it's essential to have immediate access to these catalogs and at a reasonable rate. Moreover, radio stations that air syndicated programming, commercials, and live events, they must have the public performance rights to use the full catalog of musical works in order to operate lawfully. Without it, you have the wild, wild west. No architecture, no certainty for how to proceed lawfully. Television stations have often even less control regarding the music that goes over their air. Each day, TV stations have music interspersed throughout their programming. Much of those musical performances occur in the background of stations' movies, television shows, live sporting events, local news, and commercials. Stations have no editorial control for much of their content, such as network and syndicated programming, live events, and commercials. So if a station lacked the rights to publicly perform a single musical work because it was in a repertory it did not license, it would have no practical ability to mitigate the risk that an offending song might air. This would expose the station to the threat of significant penalties under federal copyright law. Beyond the oft-discussed essential rate provisions of the decrees, NAB opposes any modification of the decrees that would allow for so-called selective withdrawals. I understand what the previous presenter said. I feel for her. And yet, as television and radio broadcasters continue to innovate in the digital space to better serve our audiences, any modification to the decrees that would enable rights holders to selectively withdraw from ASCAP and BMI to leverage their market power in direct negotiations with digital services would raise these same anti-competitive concerns. Given the complexity involved with the modifying of the decrees and the unique challenges of our nation's music licensing regime, we believe that Congress must be and is the best vehicle for modernization. Now, I know firsthand how cumbersome Congress can be, but Congress just recently legislated with the decrees in mind, and they recognized, indeed they depended on how much the industry has grown up with the decrees as an essential part of the business. Congress, though cumbersome, is equipped to balance all stakeholders' interests to develop the most comprehensive solutions for all parties. The MMA was not easy to do, but Congress eventually did it. Good ideas persisted in long enough that are fair to all concerned and practical in their application eventually become good law. So if we focus on Congress, this would, of course, ensure that all the PROs are subject to the rules and regulations governing music licensing and not just ASCAP and BMI. The ASCAP and BMI consent decrees have effectively prevented significant harm to licensees, songwriters, and consumers. And they've ensured that radio and television broadcasters are able to fairly, efficiently, and transparently license musical works to the benefit of their audiences, the American people. For these reasons, the Department of Justice should not just terminate, sunset, or change the decrees at this time. Instead, the department should work with the many legislators who weighed in during the enactment of the Music Modernization Act, and who are anxious to be engaged, by the way, and help them to develop an alternative framework prior to any action that the department may take. To that end, I look forward to the discussion over the next few days and a continuing dialogue with ASCAP and BMI and others in the industry, all stakeholders, to preserve broadcasters' access to music and to serve your and our interests as creators, publishers, and consumers. And to that end, I thank you.
Thank you, Senator. Giving our final opening statement is Michael O'Neill, President and CEO of Broadcast Music International, or BMI. Mike has been at BMI for more than 25 years. In his current role, he oversees all of BMI's operations and directs the company's growth to benefit BMI's songwriters, composers, music publishers, and licensees. I'll now turn it over to you, Mike.
All right. I wanted to say good afternoon to everybody. It's always nice batting cleanup in a group session. I appreciate that, but I appreciate what Mr. Delrahim has done by gathering us all together today for your continued efforts to review all consent decrees to determine whether they still serve their intended purposes today and whether they serve the marketplace. And I'm excited for the opportunity, of course, to continue a very important discussion regarding our consent decrees. Now, I don't think it'll come as a surprise to anybody. You've heard me say many times, we believe that the decrees should be terminated, but we also believe that an orderly transition in that termination will lead to a better world. We believe that termination will lead to greater competition, and that competition, fair competition, is a good thing. There are now 6, possibly 7 businesses that have gotten into or want to get into the performing rights space. It's kind of like the new yacht. Everybody wants it. The PRO business has become very popular, and it's not a surprise to us because we have always believed in the value of what we do and our mission to advocate on behalf of America's songwriters and composers. At the beginning of this year, BMI and ASCAP, well, we were very hopeful that we could have reached a resolution on decree reform. But unfortunately, as we all know, the COVID-19 pandemic truly altered the way we work, the way we live, and it's consumed all of our collective focus. Our businesses, all of our businesses has been touched by this crisis. The DOJ, BMI, ASCAP, the publishers, our licensees, our songwriters, and of course our composers. It's a very different world than the world we lived in just this past February. And that was why I was so happy when Mr. Delrahim called me a few weeks back and he said he wanted to put these workshops together. That all of the work we put in, that all of the papers that were submitted across the industry, and that all the conversations that we've had as a result will continue. As you know, and as you've heard, BMI's consent decree remains our contract with the government. It outlines the rules under which we do business, and it was most recently updated in 1994. That was 26 years ago. And when I say updated, it really wasn't updated much. I think it's pretty clear to say that the consent decree is out of date. I think it would be an understatement to say that. Our industry is very different and is in a different place than it was in the early 90s. First, as I mentioned, there's more competition in our space than ever before. We compete with PROs that are not regulated and are already operating under the benefits of a free market. Publishers are doing more and more direct deals with licensees. Even foreign performing rights organizations are able to license in the US. Then if you look at the licensees equation, as Beth Matthews mentioned, we are by no means the Goliath in that scenario. Then of course, technology has already altered our daily lives. It's transformed, as you heard from Michelle, the way music is created, consumed, and tracked. BMI and ASCAP, we have to evolve with those changes. We have to adapt our practices to meet the needs of those we've been entrusted to serve. And that's, of course, our songwriters, our composers, and our publishers. We advocate on their behalf every day to protect the rights and maximize the value of their music. Today, BMI is proud to represent over 1 million songwriters, composers, and publishers with more than 15 million musical works. BMI and ASCAP are the only two companies in this space that operate on a not-for-profit making basis. Almost 90 cents of every dollar we generate in licensing fees goes back into the pockets of our affiliates. We're very proud to operate with their best interests in mind. Now, equally as important are our business partners, many of whom we have long-standing, trusted relationships. People like Senator Smith and the NAB and the businesses they represent. Collectively, BMI licenses hundreds of thousands of businesses, and they're essential, these partnerships, that we've earned their trust through our service, and we have deep respect for them. Now, the music our songwriters and composers create is vital to these businesses, and these businesses are key to the livelihood of our songwriters and composers. That's our role when you think about it. It's that bridge between the people who create music and, of course, the people who use it and deliver it to listeners and viewers around the world. Now, in the last 5 years, BMI's consent decree has been the subject of 2 reviews by the Antitrust Division. The first one, we asked for. And like the old adage said, be careful what you ask for. Because instead of modifying our decrees, which was the intent, the issue of 100% or whole work versus fractional licensing was raised by the Department of Justice. I won't bog today down with all the ins and outs of that issue, but it's a model that would have seriously jeopardized the creative and financial freedom of our songwriters and composers, but also hampered licensees' ability to have access to the music they want to play. BMI had to take the DOJ to court, and let me tell you, that's not very fun. It wasn't a good day when that happened. It wasn't, I'm happy to say it wasn't Mr. Delrahim, it was his predecessor. I'm also happy to say that we won. The second review is the one currently taking place now, and it wasn't raised by us. It was started, as you heard, by the DOJ in their effort to review all consent decrees. And while we didn't start it, we once again are hopeful for change. As you've heard, there are no modern decrees that live on in perpetuity, so we welcome the idea of terminating them as long as it's done gradually and thoughtfully. We believe that a free market is the best way for music creators to be rewarded for their hard work and intellectual property. It would create a more productive, efficient, and level playing field for everyone. But we also understand that change is hard. Our decrees have been in place for nearly 80 years, and suddenly terminating them, we believe, would cause chaos in the marketplace. And we want to avoid that at all costs. And that's why, as Beth said, Coke and Pepsi came together and issued a proposal that would gradually lead us to a free market while protecting all parties. We proposed an orderly transition that includes actually forming new consent decrees, which, like all modern decrees, would include a sunset provision. In discussing this with our licensees, we determined that the new decrees should contain 4 key provisions, or the core 4 as we like to refer to them. First, it would allow all licensees to gain automatic access to the BMI and ASCAP repertoires and the ability to immediately begin playing our music, as long as they also begin paying immediately. Music is not free, and neither is any other type of intellectual property. Second, we would retain the rate court process for resolution of rate disputes as refined by the MMA. Let me mention that for BMI and for ASCAP, the overwhelming, the vast majority of deals are done at the negotiating table, not in court, as some have said. The judges rarely see us, but when they do, it is always over a dispute. We're saying that we would keep that resolution mechanism. Third, we would preserve a system that allows songwriters and publishers to do direct deals with licensees. As we've seen over the years, this is an important provision, not just for our licensees, but also for our publishers, songwriters, and composers. And fourth, at a minimum, we would keep the current forms of licenses that the industry has grown up with, grown accustomed to, while allowing us to offer new forms of licenses and experiment with innovative business solutions. Now, I want to be clear that these provisions don't necessarily benefit ASCAP and BMI today, but they benefit the industry and will help facilitate a meaningful transition to a free market. But I caution us, we have to be vigilant. As we've seen, and as you'll hear, there are some organizations that are using this moment to their advantage. Unregulated parties and licensees are using this review of our consent decrees to try to increase regulations on BMI and ASCAP, not for the benefit of the songwriters or composers, but we believe for their own benefit. Frankly, this just amazes me, and it's completely contradictory to what the DOJ is trying to do. Issues like 100% licensing, length of songwriters' contract, payment schedules, similarly situated licenses are all coming into play. Issues that are more about regulating the marketplace through our consent decrees than the actual consent decrees themselves. And then, as you heard this morning, there is a position being raised by the National Music Publishers Association on rights withdrawal. Today, the majority of digital deals are already done on a direct basis with the publishers. The publishers have already bundled most of their rights and done direct deals that don't involve BMI or ASCAP. That being said, overall, we agree with the concept. However, where we disagree is on the timing. I truly believe that advancing this issue now, given, as you've heard from the NAB, how divisive this concept is with music users, we will find ourselves with a push in Congress for compulsory licensing. To think otherwise is simply foolish. And by the way, that push in Congress will lead us right back into discussing whole work or 100% licensing, which we all fought so hard against. You've heard the NAB's position today. What do you think the digital companies' positions are today? Withdrawal may be what the publishers want, but this outcome, this push in Congress, would not be in the best interest of our songwriters, and thus we can't be for it. Let me stress, compulsory licensing is not where we want to be. It may seem like an easy and efficient solution, one license, of course, that covers everyone for everything, but that's far from the truth. It would have dire consequences for the music business. First, we've seen compulsory licensing depress pricing. Just look at the history of mechanical licensing. Second, it means even more government regulation, and we see no scenario in which more government regulation of the music industry would benefit anyone. We need to ensure that the profession of composing and songwriting doesn't simply turn into a hobby, because no one can make a sustainable living by writing music under compulsory licensing. Our plan would avoid this, while giving the market time it needs to adjust. Once we get there are antitrust laws already in place, and of course, people like Mr. Delrahim that would continue to govern all parties when the decrees eventually go away. And I want to note that in nearly 80 years, BMI has never been found by the Department of Justice to be in violation of the terms of our decree or any antitrust laws. In closing, I think it's fair to say that there are a lot of different perspectives on decree reform, but there's also a lot of points I'd venture to say we all agree on. We all want more transparency, and I have to respectfully disagree with Senator Smith, as the info is already available, and we're simply making it better each and every day. We all believe that competition is beneficial and necessary. We want to see change, and we want to do it in the right way that makes sense for everyone. I'm confident that we can find a path forward together to ensure a vibrant future in music and for the businesses that use it. Mr. Delrahim, once again, I want to say thank you for shining a spotlight on these issues. With our proposals, we believe that we will protect competition, drive innovation, while ensuring that the American songwriter and composer are fairly compensated for their work. I want to thank everybody who was on the panel today, and especially, once again, thank you, Mr. Delrahim.
Great, thank you, Mike. That concludes our first session.